consider, in your view, as being important arising from your evidence?
Chairperson, without repeating what I've stated in my affidavit as submission to this committee, the point I really make is that Ms. Mqwebane, as the incumbent of the Office of the Public Protector, as the Public Protector herself, as prerequisite is also required to be an advocate, rendering her an officer of the court. In both instances, both as a prerequisite for appointment as Public Protector and for admission as advocate in South Africa, people are required to be fit and proper. I believe that the facts that I've put before this committee suggest that Ms. Mqwebane was not honest and factual in respect of case number 48521 of 2019. And in fact, I don't believe she conducted a proper investigation and that she was biased. I think she had already made up her mind that the unit was rogue because she referred to the unit like that. She openly stated that the persons associated with that unit that she was still in the process of investigating had been involved in the deaths of people, and she predicted further deaths and threats of people since her investigation had started. And the fact that she failed to come to the one person who I believe was most capable of providing her with the facts is an indictment on the quality of the investigation. I can only conclude it was either incompetence or lack of effort to even do elementary aspects of the investigation. Alternatively, something worse, and may well have acted fraudulently by omission. One example of several that has been traversed during my testimony yesterday was the withholding of the fact that Ms. Mqwebane was in fact in possession of the 2014 Inspector General of Intelligence report, and she did not provide that to those people that were implicated in her investigation to respond to. There are many other examples which I addressed in the court papers, and the court has expressed a final view on the facts before it, both by Ms. Mqwebane and by myself, and those facts stand. The matter has been ruled upon, and I then make the point that even then, when I did have an opportunity somewhat to put facts to Ms. Mqwebane post her investigation, she remained unmoved. It was as if I'd said nothing. She didn't respond to it. She didn't dismiss it. She didn't waylay it or engage with it whatsoever. I quote from a constitutional court judgment, which I'm not going to do again, but I've plagiarized from that judgment, which states that the incumbent of the position of public protector is required by our constitution to be independent and impartial. And the constitution demands that powers are exercised without fear, favor, or prejudice. And it's then expressed, I think, in the Supreme Court of Appeal that those words, fear, favor, or prejudice, are not just rhetoric. They mean what they say. And it calls for courage at times, and it calls for vigilance and conviction of purpose. I submit to this committee that Ms. Mkhwebane, in my case, failed to act without prejudice. She accepted unsubstantiated claims and wild accusations, which I proved to the court, and she elected not to engage on those at all.
Recording
So
in
that's that.
progress.
And I make the point, which I also made to the court, that had Ms. Mkhwebane afforded me a hearing, then a lot of time and effort and money and heartache and trauma on many, many people, and whatever resources had gone into that investigation and the subsequent litigation and the aftermath would well have been curtailed, if not curtailed. And justice would have triumphed. It did not triumph in this instance. And Ms. Mkhwebane would have heard from me, the very person who managed that unit for the almost the entire period of its existence. But more importantly, the entire nation would have known. And I submit that Ms. Mkhwebane failed the tests of what the court calls courage, vigilance, and conviction of purpose. I just elaborate then on what the features of an investigation ought to be in terms of the Supreme Court of Appeal. It's my view that the investigation was not an investigation, it was something else. It was a copy and paste exercise, and it was just taking something that had been regurgitated before by the very same people and put up as if fact, and then making multiple errors. Simply put, my basic human rights and natural justice applicable to me and many others, including every single person in that that was ever a member of that unit, was simply cast aside by Ms. Mkhwebane. I also make the point that I have absolutely no desire to sit before this committee to debate the merits or the details of the matters, because they've all been ventilated before courts. They stand, the court has ruled. I don't think that's the purpose of this committee. It's not my understanding of the purpose of this committee. Whatever I had to say about that specific unit and the investigation report 36 of 2019-20 of the Public Protector under hand of Ms. Mkhwebane, I had stated in a number of affidavits on oath before our courts, and I made the committee aware of those, and the committee is in possession of those, and they are fact as we sit here today. They are incontrovertible. And I just make a point of the irony that, and it's something I alluded to yesterday. I try to imagine being in Ms. Mkhwebane's shoes and not being allowed to participate in the process that I'm appearing before and in the process that I'm about to be subject to by her legal representatives. And it was very easy for me to imagine that, because that's what had been happening with me for the last 8 years. Thank you, Chairperson.
I have no further questions.
Thank you, Advocate Sibawa. Thank you, Mr. van Lochrenbeck. Just before I move on to Advocate Mpofu, I just want to recognize the hand of Honorable Maute. Honorable Maute.
Yes, Chair.
Thank you very much. I was struggling with the network this side. Thank you, Chair, and good morning to everybody. Chair, I want to raise an issue that happened yesterday. And I think this committee is a committee of parliament, and it follows the same rules as the rules of the House of the sitting of Parliament. And as such, they are expected here, and also that it is a long session. I mean, is very late.
We can't hear you. You're breaking up. We can't hear you, Honorable Mautwe. You're breaking up. Might have to
I was very
reposition
disturbed
yourself.
by the video that I saw yesterday, whiskey in his hand. And perhaps he can clarify whether he was drinking during the... Sorry, Chair, I will try to. Chair, can you hear me now?
Okay. Can speak, yes, can hear you now.
Thank you so much. I don't know where you didn't get me. Should I start from the beginning?
Yes. It's okay.
Okay, Chair, I'm saying that this committee that you are in, it follows the same rules as the rules of the House, because it is a committee of parliament, and as such, it assumes that you are in the House sitting of Parliament. And as such, we as members of this committee are expected to have a certain conduct. And we understand that this session is very long. Some of us are on visual, it's the whole day. Sometimes it runs into the early evening or late evening. But Chair, I was disturbed by a video yesterday of Mr. Logenberg holding a glass of whiskey in his hand. And perhaps he can clarify whether he was drinking during the session of Parliament or not, because if that is the case, Chair, then it poses his whole testimony of yesterday null and void, because if you're under the influence, I'm sure the legal gurus will assist us. What happens when you're under the influence, whether your testimony can be considered or not. But I just want us, Chair, to give him an opportunity to clarify whether he was drinking during the session of Parliament or not, because there is a video. If you don't have, Chair, I can make it available to you in the committee, but that video suggests that Mr. Logenberg was drinking whiskey. I thank you, Chair.
Thank you, Honorable Mautwe. As a chair sitting here, whenever there was an opportunity for Mr. Johan van Lochrenberg to speak, I did see him drinking coffee, but I might have missed miles away seeing him drinking whiskey. I quickly, and it's going to be a quick thing, Mr. Johan van Lochrenberg, simple. Were you drinking whiskey as you answer? Well, I've never seen any glass. You are drinking coffee from, as far as I'm concerned.
Chairperson, if it may assist, I think I'm aware of the video clip that the honourable member is referring to. It's me standing up at the end of, I think, or just before you break for lunch, and the camera is still on, and I have a glass in my hand, like this. If I can pick it up for you now, you can see it.
Thank you.
This glass contains medicine. I'm undergoing reconstructive
thank you,
surgery in my mouth.
Thank you, Johan, Mr. van Lochrenberg. I am very satisfied with that. We're now going to proceed. So, Honorable Ngola, you had your hand up? You had your hand up, Honorable Ngola? Okay, thank you. I'm about to recognize you, Advocate Mpofu. With Advocate Bauer having concluded, I now want to take this opportunity to refer to the Public Protector, legal advice team led by Advocate Mpofu to start the cross-examination. I recognize you, Advocate Mpofu.
Thank you, Chair. No, it's fine. What I was going to say, I'm sure will be covered in the questioning. Now, Chair, if you may, with your permission, allow me just to address the committee for a few minutes. I promise you, I won't try to beat the record of the previous address, but just to situate what I'm going to say. Yeah. Chair, I think it's important for me to say this before I pose any questions. I'm going to cover two broad issues, but I'm again, without necessarily debating them. One is, it's very clear to me, Chair, or it should be clear to all of us, especially after this witness, and I suspect the next one, that the ambit of what they cover is very, very wide. And I cannot even tell you how many people have come out with offers of giving evidence and all sorts of things just since yesterday. I've been inundated with those. So this evidence, as all evidence, spans all sorts of other possibilities of what might happen. And Chair, I'm saying this with all humility. I think that you must brace yourself for quite an extensive inquiry, because we're not going to leave things that have been said here unaddressed, just so that, you know, we can go through the motions. This is a very serious process, and I think at least everyone in the room agrees on that. And if the first witness, as it seems now, is going to necessitate the kind of work that needs to be done, I can just mention for a few things. For example, he has commented on 4 independent investigations that were done at separate points. And he has suggested that those were discredited or not worthy, or not worth the paper they are written on. Now, that would immediately necessitate that the committee be in possession of all or some of those reports. Because here, and as I said on the first day, this committee is not here to just rubber stamp or to confirm that a court found X or Y. And I know you and I agree on that one, Chair. Because if that was the case, then we don't need this. Everyone here can read English. So they could just take their judgment and read it. And then we all know that the court found what it found. There's no need for us to be gathered here for that. We're here for something completely different called an inquiry. And that word is used advisedly, to inquire into the allegations of misconduct. Whether those allegations of misconduct are based on, let me not use you as an example, Chair. Anybody, it could be a person in the street who says, I have come to the conclusion that Advocate Mkhwebane is not fit to hold office or is guilty of misconduct and so on. That person will say it out there in the street or write to you or to the speaker. And if a member converts that into a motion, then we will gather here. So we can't just say, we're gathering it here to convince ourselves that Mr. John Smith said that the public protector is unfit. What we gather here for is to inquire into whether what he or she says is indeed so, or as the Constitutional Court puts it, whether that ground exists, and then we move on. So the fact that that opinion or view comes from a court, really, it doesn't take the matter any further. It is true, of course, that a court has a particular status in society, like a minister has a particular status in society. But the fact that an allegation would have come from someone working in a taxi rank or from a minister doesn't change the nature of the inquiry itself. It's simply, or if it comes from a bishop, we might think that it already comes with a bit of weight than if it comes from a servant. So that's really the only relevance of the fact that some of these opinions come from a court of law. Now, let me just take one example. If the court says the public protector did not take into account the Inspector General's report, for argument's sake, and therefore she did not meet the standard of a public protector. I'm just paraphrasing something. Again, at the risk of sounding like a broken record, yours will not be to inquire as to whether the court indeed said that, but as to whether she indeed ignored the report. And I'm saying that just for context. I'm not patronizing you, Chair, or I'm not suggesting that you don't know what I'm saying. I'm just giving you the context. Now, we're dealing here now with only one of the charges at the moment, to do with the so-called rogue unit narrative and all that. So we're going to go through the same exercise painstakingly around FRIADE, around CX, around all sorts of GEMS report, on your new widened definition around everything, Busasa, around Baloi, even though the independent panel says there's no prima facie evidence, but on the decision of this committee, we have to go through all that. Now, each of those, like this one, and I'm saying this because I have realized just from yesterday till today, just in preparing for this session that we're going to go into, that actually it might not even be possible to finish this witness without having to bring certain evidence, or for us to consult with certain people just because of things that could not be predicted. The stuff that could be predicted we're ready for, and I'm going to deal with it here. And Chair, I hope you believe one thing, which is that we are committed to this process under the conditions that I've already gone into. And that's why we will, even with this, we will go as far as we can, but I'm simply wanting to indicate that there might be off-ramps and other issues of that type. And I say that in relation to this witness, and I suspect the next one, Mr. Pillay, who will, if you remember, Mr. Pillay will not only deal again with the so-called rogue unit narrative, but is also going to deal with his retirement, so-called early retirement, to do with Mr. Godan. And that's, I can assure you, because I was involved in that case, we had to sit before 3 judges for 3 days, which is not usual, just debating that particular issue. As lawyers, we had to be given what is called a special allocation, just because of the sheer volume of matter involved in that one case. So that I just want to flag that, Chair. Sometimes they say, be careful what you wish for, because you might just get it. So we wanted an inquiry. It's here, and we're here. But it's not going to be I suspect, what we thought it was going to be. And without being alarmist, let me just tell you, Chair, and this one is directed at you in this example, because you are sitting in the place where Deputy Chief Justice or Chief Justice Zondo was sitting. That process was meant to take 6 months, and it took 4 years, and even the report was even given outside of the time that it was meant to.
And in this process, we have our report in September.
Yeah. Well, thank you, Chair. That's what the Deputy Chief Justice said as well. Until 6 or 7 times later, he had to ask for extensions. On a serious note, Chair, let me put it this way. If this process is going to be fair and cover the ground that it needs to cover, you will never finish it in September. I'm telling you now. On my estimation, that's just a view. I might be wrong. Yeah. But I wish you could finish it tomorrow, obviously, because for us, it's, people have been talking about the poor. The poor are sitting there waiting for their public protector. And she's sitting
September
here.
was not meant to sidetrack you.
No. I'm just simply saying, no, but you assisted me, Chair, because I wanted to make the point that, of course, we can finish next week. I mean, there's nothing stopping us. But I'm saying if the process is going to be fair and cover the ground, that even the new ground that you have now redefined, then it's going to take a lot more time than that. Yeah. Anyway, I'm just putting that out there. The second point is about witnesses. Oh, by the way, Chair, I'm sorry, can I just inquire, have the directives been adopted now? Remember on Tuesday, you said you were going to, I don't know, have a meeting of the committee and so on. So, but on the record, we don't know whether the directives have been.
They'll be issued today.
Pardon?
They'll be issued today.
They'll be issued today. Thank you.
But the evidence leader will speak to you.
Okay, thank you. Thank you. Yeah, and she tried to speak to me, but I was consulting. Thanks. Maybe it was about that. All right. Well, if they are going to be adopted or issued.
Issued. That's
yes,
a key word.
By you, yes.
Yes.
That means they've already been adopted. They'll now be issued. Yes, thank you, Chair. Then it means we're in the area of dealing, among other things, with the witnesses, with the method of calling witnesses here, which was discussed 2 days ago and adopted and now will be issued. The theory of that clause, if you remember, honorable members, is simply that we should identify a witness, both sides, call that witness, or rather approach that witness. If the witness is willing, well and good. If the witness is unwilling, then the processes of summoning that witness must then be initiated. I'm just paraphrasing. Subject to all sorts of things, you have to demonstrate that you have you tried the voluntary route and so on. Yeah. Now, the tricky part, that's not just unique to this process, in any process, is that as the evidence develops, obviously certain witnesses that you might have not even thought about become necessary.
It's a dynamic process.
Yeah, always, yes.
Yeah.
And that is what is happening now. But I want to comment on one thing. When I spoke to my learned friend on Sunday, when we were talking about the witnesses. And one of the things I said to her was that we intended for one of the charges, the one to do with Busasa, CR17, that we intended to call the president as a witness. And her response was, well, you have to do what you have to do, which I would have responded the same way if she said it to me. And I don't want to enter the debate you had with General Holomisa yesterday, because that statement we had made it was unrelated to that. And I just want to explain that we are going to call the president. We are going to write him a letter today or tomorrow to ask him in line with the directives if he's willing to come voluntarily. If not, then we will initiate a process for him to be summoned. And it is not for the reasons of dealing with the issue of suspension and all that per se, but just on the merits, on the fact that he has made certain accusations against the public protector, saying she's guilty of perjury and all sorts of things, which would be impeachable if they are true. But you'll see that when we do when we send the letter. But the point is that actually I had then thought that would probably be as far as we go. But from some of the evidence now, and I suspect that will come from the cross-examination, it looks like we might even have to call other former presidents. I don't want to put their names at this stage, but you'll remember one of the charges has to do with a meeting with a president. Again, and that might not be necessary. For example, we could go to that person and say, did you meet with the public protector? The person might say yes or no. We go to the evidence leaders. They say, okay, we accept it at face value. Then obviously we can't call someone here for something that would have been agreed. We'll simply register to the committee that this has been agreed. But I suspect that with some of these people, it's going to be not that simple. With some of them, it might be that simple. But Chairperson, that is, those are the issues that I've just been asked to place on record for now. We'll continue to engage, and we will keep you abreast as to the developments. But if any of those processes they might have hitches, some of them might even end up in courts of law, I don't know. But that's what we intend to do. And we're going to do it. We're going to do anything that is going to assist this committee in answering the question as to whether the alleged grounds in Ms. Mazoni's motion have been established or whether they exist. And we will do that without any fear or favor. And particularly for those matters that are actually covered in the charges. Thank you, Chair. I just wanted to place those two matters. I don't want to call it fear, the scope matter, and then the issue of what you call the dynamism of the process, and the fact that we already can see certain patterns. And I've just mentioned two of the charges, this one and the one of CR17 and Busasa. There's probably another 10 charges for which what I've just said applies equally or even with more force.
Okay. Are you now ready to start on the witness?
Yes.
Before that, I will recognize Honorable Melder.
Thank you, Chairperson. I think it's important that we deal with what Advocate Mpofu has just now put on the table as well. Just from my perspective and my view, I first want to say I welcome it that Mr. Mpofu indicates that they are here to assist the process. I think that's constructive and very positive. But then I also must say, and that's just my personal view, I do get the impression that there's a strategy to keep us busy until the term of the public protector expires. But that's just my view. I may be wrong. It's my view. Mr. Mpofu also says there's a new way to treat this whole process because the new ground that we have set, I think he refers to the committee. I'm not aware of any new ground being set. I think we are dealing with the process in terms of what was set out right from the beginning, and also in terms of the motion that Parliament adopted, and that is our frame of reference and our instructions. He also just now referred to the crimes. I'm not sure that there's any crimes being referred to in the motion. I think it's a question of inquiry or committee that looks into the conduct of the public protector in terms of she's a fit person to hold the office. And then Mr. Mpofu, Advocate Mpofu, goes along and he tries to convince us by saying that we cannot take the judgments of the courts on face value, basically. Those are, and the words were, there are other institutions that also makes allegations. He referred to the example of ministers, etc., etc. I find it a bit strange. I don't think, and he also said these opinions, I don't understand that they are allegations or opinions. I think they are legal findings by legal bodies, namely the courts in South Africa. And I think the committee will treat them as such. That's just my view, that these are findings by courts. And you'll remember that on day one, it was said by the evidence leader, and I think that's exactly the correct position, that this committee is not a court of law, it's not a quasi-judicial body, it's not a criminal procedure, it's going to do its work in terms of determining, in terms of its powers, and then it will make recommendations and report to Parliament. So I think from my perspective, if Mr. Mpofu, Advocate Mpofu, and the Public Protector are in the impression that we are going to do the work that's already being done by the courts in South Africa, I think that is a completely wrong perception of what's going on. It's not our task to be the court of Parliament. That's not our task. We deal with the facts as we've got them, and maybe we can easily deal with them. Certain questions were asked yesterday and certain allegations were made, and if we are given the opportunity to ask them directly to the Public Protector herself, she could answer them. Lastly, I would like to understand if Mr. Mpofu says he wants to summon the president or former presidents. I'm under the impression that the power or prerogative to summon witnesses lies with the committee. Maybe Advocate Mpofu can assist me in and indicate in terms of his interpretation what would give the Public Protector the right to summon witnesses. That could assist. Thank you, Chairperson.
Thank you, Honorable Melver. I've noted the Honorable Ngola, but I'll quickly go to Advocate Mpofu.
Thank you. No, let me start with the last one, the easy one. Yeah. No, you're quite right, Honorable Mulder. The power of summoning is with the committee. That's exactly why I started by asking whether the directives have been issued. But you and I know, or at least should know, that that power is triggered by either the evidence leaders or by us. It doesn't just fall from the sky. So if we need a particular, the witness, this thing called a witness is either a witness for the evidence leaders or for us. So it's only us. And I suppose the committee can also call whoever it wants for its own purposes, but I'm not there. I'm talking about witnesses of the parties, so to speak. So that's a simple thing, yeah. While the power does reside with the committee, but it is triggered by the person who wants a witness, logically. Yeah. And I'm just saying that that person in the case that I just meant is the Public Protector. So I don't think we need to quibble much about that. The next one is this issue, and I don't want again to get into, I spoke about all these things in my opening address. The fact that this is not a court of law is exactly the problem. Okay? If it was a court of law, it would be simple because you'd just be bound by decisions of a higher court. It would be a straightforward matter. It is exactly because it is not a court of law that you are not bound by views and fine courts. Even if you are, you would be bound, I've explained this again before, you would be bound by the legal findings. You cannot be bound by the facts, okay? Even a court is not bound by factual findings of another court. They are special, it's a whole area of law. I don't want to get into it now. Yeah. So, and the distinction between questions of fact and questions of law is a matter that lawyers have debated ad nauseum. So if you think it's simple, then I'm afraid that will be part of the problem. And you say I talk about crimes, you're not here for crimes. I've just told you that the president accused Advocate Mkhwebane of perjury. That is a crime, sir. It's a crime in this country, at least. So some of the issues that you're going to deal with will be conclusions of I have a list of some of the comments that were made that this logic is fallacious or this is egregious. Those are conclusions. And for you, you'll agree with those conclusions or not agree with them. But where it is a direct, if someone says that the public protector is guilty of a crime, then it is a crime. It's not me who says that. And that person is going to come here and justify that accusation. Or you cannot take it into account. So the nature of the accusation is not in our gift. It's whether it's in the gift of the person who makes that accusation. New grounds in terms of parliament? No, I'm sorry. If I'm not being facetious here. When I say the new grounds, I'm simply saying that the definition that we had asked, whether you will be confined to the issues in respect of which prima facie evidence has been found, or whether you will reintroduce the sifted material. I used the example the other day of when you sift stones and leaves. So you can either then take the product or you can put back the stones and the leaves. In my language, in isiXhosa, there's a test that is used where they want to check and they give you a bucket to go and fetch water, but they open things around it. If you really use it and go back, and then they know that you're not okay. Yeah, so I'm simply saying that it's either after the sifting we put back the stones or we don't. If we do, it's again, that's not my prerogative, it's yours. You've made that decision, I respect it, but I'm just talking about the implications thereof. Yeah, that's all. The last one is something that, Chair, I would like you to ask the honorable member to please withdraw, because we've been talking about respect here, and we've said that we respect this process. But respect, contrary to popular belief, is a two-way process. We will respect those who respect us. So to say that there's a strategy to keep you here until the end of the term of the public protector is a serious accusation, either against her or even me and my team. And I take, speaking for myself and for the public protector, very strong exception to that suggestion even being made in this hallowed house. I have said we've been accused of this, and it's a very serious accusation. Actually, if that is true, if what you're saying is true, then we must not have this inquiry, because it means she's a criminal, as the president calls her. If she can come here to waste the time of this august body to play a little game so that she can finish her term. So that is not the case. We're here to do the exact opposite, because we've been getting these insults and slanderous remarks being made that when she takes the matter to court, it means that she's playing for time, even though the courts have vindicated her. And that's why she's here sitting painfully in the belief that this is an illegal exercise, but out of respect. I've said this before. So I'd humbly ask you, Chair, to for that remark to be withdrawn. It is false. It has no basis. It has no evidential basis. And if I'm simply saying that this might happen, I've even used the example of the Zondo Commission. I don't think you can say Justice Zondo sat there for 4 years because he just wanted to sit in Braamfontein for 4 years until he becomes Chief Justice or something like that. And that would be absurd. We're doing the exact opposite of what we're being accused of, Chair. But we're going through a process that we know is not even supposed to happen to stop these kinds of accusations. Thank you, Chair.
Advocate Mpofu, I hope that just after this, you're now going to be ready to interact with the witness.
I will.
Honorable Melder did say he is raising his view, and Advocate Mpofu is not comfortable with the view you're raising. You want to make a comment on that?
Yes, Chairperson. I heard what Advocate Mpofu said. I didn't address myself to the public protector, but I addressed myself to you. Other allegations that were made perhaps in the press or somewhere in the past with regard to legal proceedings, I didn't make any of those allegations. I listened to your input this morning in terms of how you see the process, and you want us to do what's been done over the last couple of years in the courts. You expect us to do that. I gave you my perception. I didn't say that that is the case. I didn't say the committee says that's the case. That is my perception. It's still my perception, but that's a perception. I guess I'm entitled to a perception, and I didn't state that as a fact. Luckily, I think you will prove us that I'm wrong, that my perception is wrong, and that's to you.
Honorable Mwala.
Thank you very much, Chair. I think, Chair, I just wanted to caution your guidance in the committee that the proceeding should not lose shape. We have a witness on stand that submitted evidence. The evidence leaders have concluded their cross-examination. Now, expected in terms of the operations of the committee is that the team of the public protector should proceed with cross-examination. Because as I'm listening from Advocate Mpofu, he has said a lot already, which is not covered in what the witness has deposed. Advocate Mpofu does not need to make an address on the intention of their team to bring a witness in this committee. He knows where and how they are going to bring witnesses to this committee. There is no need to make an address about it. The proceeding chair will organize rallies outside, not here. Can you proceed, Chair, please? Thank you.
Thank you, Honorable Mwala. Honorable Lagude.
Thank you very much, Honorable Chairperson. Good morning to you, my colleagues, the Public Protector and her team. Honorable Chairperson, I want to agree with the Honorable Ngola that this train must not be derailed. We are a committee established based on the resolution of the National Assembly. We adopted the terms and references. We are guided by the rules of the National Assembly on how to operate. Then we don't have any new grounds that are there for us to proceed with the inquiry. The grounds that we are working on are the grounds that are stipulated in the Constitution of the Republic of South Africa. So what happened is that when the rules were established, working with the parliamentary legal team, we went as far as defining those grounds. We understand, Advocate, both through you, Chairperson, that legal people, legal minds, sometimes they don't agree themselves. So let's not derail this process. Let's proceed as per our expectation, as per the expectation of the people out there and also of this committee. And also we do have the witness that is waiting up there. We have questions to that witness. Thank you very much, Chair.
Thank you, Honorable Labude. Your last hand, Honorable Siabi.
No, Swele, also my hand is up, Chair, on visual.
We see all the names, member. Go ahead, Honorable Siabi.
Thank you, Chair. And let me also greet all who are in the House. Chair, to an extent, I'm covered by the Honorable Dakute, but I just wanted to add that from the side of Parliament, we have sourced the services of Ms. Power, the legal, the evidence leader. From the side of the Public Protector, she has sourced the services of Advocate Dalimpov. And our expectation is that the two, together with the chairperson, need to have a backroom office and deal with other issues, especially issues that are raised by Advocate Mpofu, so that by the time we come here, they've cleaned certain things, because it will be seen to be wasting time if we want to clean issues in the sitting. But we take that every time, like they have reported, that they are able to call each other at night, in the morning, and so on. In collaboration with the chairperson, they are able to clean certain things. And where they can agree, they have serious differences to take a decision. That's when they can come here. I think that's the reason why we source the services of such professionals. So I would also add my voice to the honorables that let's take that route, so that when we come here, as we convene in this fashion, we're able to be effective and move on. Thank you, Chair.
Thank you. Honorable Swela.
Thank you, Chairperson. I won't waste time. I think I'm covered by the Deputy Chief Whip and other colleagues. My humble appeal is that as the committee, we know exactly why we're here. So as we have adopted the time frame of this process, and again, according to my understanding, we're here not to accuse anyone, and there's no one who's guilty before us. We're here to listen. Is then that we're going to take any determination. So my humble appeal is that let's God help us to deal with this process in a scientific way, in such a way that we don't harm each other. That's my humble appeal, because I was completely lost about what Advocate Mpofu was saying here. Not to add to utter what other speakers have said, Chairperson. We don't want to lose focus. We're here. This is not really a court, it's true. And we respect our legal teams, we respect Advocate Mpofu, but the session must respect us also as a committee. Yes, we are not legal gurus, but we rely on them as our experts. So my humble appeal is that let's proceed. Let's listen to those witnesses. And then, because as committee, we need to jot down issues during our time when we cross-question them. We must have facts, but to add a lot of things, it might confuse us. We are here to listen to those witnesses. Can we proceed in that way? Thank you, Chair.
Thank you, Honorable Suela. Advocate Mpofu, as I had indicated, no, there's nobody else. Please proceed, and as I indicated, you might want to give brief comments, but I would want you to proceed to the witness.
Yes. No, thanks, Chair. I won't respond to everybody because I think 3 or 4 of them were saying the same thing.
Chair, apologies. I don't want to be seen as a person who's interruptive and all that. But I don't know if we are ever going to proceed with these hearings. If everyone who's submitting their opinion here, Advocate Mpofu is supposed to respond. We did not ask questions here, Chair. We just submitted, just like he did. He did submit his views. We did submit ours. Then we're waiting for the guidance of the Chair. There's no need for Advocate Mpofu to respond. Okay, please, Chair.
Thank you, Honorable Ngola. Advocate Mpofu has already been directed to engage with the witness, but Advocate Mpofu started this session and asked that he wanted to create a context and made general comments, and I allowed that, and I'm going to do that with the evidence leader and himself. It's clear that the context he has created has invited the reaction. So I would want you, as I indicated, because we have the witness until 3, that you start interacting with the witness, but I cannot stop you if you want to just make your final comments on what you have heard.
Thank you, Chair. No, I would have been finished by now. Now, Chair, as I was actually, the member interrupted me when I was saying I'm going to be short because many people said the same thing. And that same member accused me of a rally and he doesn't want me to respond now. So we're not going to be insulted, Chair, gratuitously, and then be gagged from responding. It's not going to happen.
Advocate Mpofu.
It is misleading to say that I accused Advocate Mpofu of a rally. All I addressed with Advocate Mpofu was that he knows how to summon witnesses to appear in the committee. I have said, I referred to myself, that we will call issues of rallies outside. I said we. I never referred to Advocate Mpofu. Can I not be accused in this committee, please?
Okay. Thank you, Honorable.
Chairperson.
Clarifying yourself.
Person.
Honorable Malema.
Chair, we're not going to be abused here by Honorable Nolan, who thinks that he's got something special to offer when he's got nothing to offer. He thinks that he's a politician wannabe and makes unnecessary statements and then come and accuse people of delaying this process. We're all here quiet, Chair, listening. He says Advocate Mpofu commented and they commented. Then he doesn't understand why Advocate Mpofu must comment again because they didn't ask questions. Why did he comment when Advocate Mpofu didn't ask questions? He commented. He was telling us what he's going to do. All you do is to allow him to say what he wants to say and say to him, proceed. But you're allowing him to comment because you're commenting on him. He accused Advocate Mpofu of a rally and he wants to come here and somersault thinking he's the best politician this country has ever offered. He must not be like that. We've been keeping quiet here.
Honorable Chair.
You can call it the way you want. That is going to be the game if you are going to start like that. You must know now, this committee is going to be characterized by that. If you think you can call order when you have been out of order throughout, and we've been tolerating your nonsensical inputs here, then you must know this is how we're going to proceed.
Honorable Malema, thank you. Please, I want you to refrain from that language. Thank you.
It's nonsense, Chair. To say it's nonsense is parliamentary. It's nonsense.
Thank you, Honorable Malema. Colleagues, I would want you to please drop your hands. Advocate Mpofu.
Thank you, Chair.
Um,
Anyway, all I wanted to say is that the proposal of the backroom office is a good one. And we already have that, as you indicated, Honorable Member. And sometimes we even chat to the chair informally in an effort to try and curtail the technical stuff. But everyone who talks about derailing and wasting time is just missing what I'm trying to do here, which is the exact opposite of that. Because and also the sense of intolerance, Chair, must not be uneven. Because yesterday on a lighter note, commented about the 45 minutes that was taken, put in context by the evidence leaders. But now, when I address fundamental issues to preface my cross-examination, there's a whole lot of insults being thrown in our direction, which is completely unfair. Anyway, Chair, I'm going to move to the witness, but I just want to say this about I have no confusion about what I was talking about the wide scope and the narrow scope. And I want to leave you with this question again to think about it overnight. What was the point of wasting those millions of rands having the independent panel if that work is not going to be taken into account? That's all. Now, Mr. van Lochenberg. Mr. van Lochenberg, are you still with us?
Yes, Chairperson.
Thank you. You described yourself as a whistleblower, correct?
That's correct, Chairperson.
Where did you blow what whistle?
It's evident in my affidavit from paragraph 3, where I invoke the Protected Disclosures Act, and I submit everything I state in the affidavit in terms of that.
Do you know the Protected Disclosures Act is an act that protects employees from disclosing information? What does that got to do with this?
I was a former employee of the South African Revenue Service. The matter concerns the Revenue Service.
So you are a whistleblower now at the Revenue Service?
Yes, Chairperson, the latest amendments in the Protected Disclosures Act extends the description of employee to include former employees.
No, that's in respect of dismissal, but that's fine. So when you're saying you are a whistleblower, you mean in relation to SARS, to your employment at SARS, which ended in 2014?
Which ended in 2015, Chair. And
okay.
I'm referring specifically to the definition employee as contained in the amended Protected Disclosures Act.
No, sir. Okay, let's say I don't want to debate issues of law with you. I'm saying, let's assume you're correct with that. But that reference I'm asking is therefore with referral to your employment at SARS, which ended in 2015.
That's correct, Chair, because the report relates to that.
All right. Now, so while we are on the subject of that employment, you were suspended from SARS at some stage, correct?
Just repeat, sorry.
Were you ever suspended from SARS, from your employment?
Yes, I was, Chairperson, in November 2014.
November 2014. Okay. All right. Well, so I think let's just talk about that quickly since you want to talk about employment. And why were you suspended?
I don't know, Chairperson.
You don't know?
I don't know.
You were not told what happened. You just told you are suspended. There were no accusations, false or true, that were made.
Correct, Chairperson. I was informed the day that I'm suspended.
Full stop.
I beg your pardon, Chairperson.
Yeah, no, I'm saying you were just told, Mr. van Lochenberg, you are suspended. You're not given any reason.
Correct, Chairperson. I was told I was not entitled to the reason for the suspension.
Right. And were you not accused of sharing taxpayer information, confidential taxpayer information?
I've been accused of unlawfully sharing taxpayer information on multiple occasions over many years, Chairperson.
No, Mr. van Rottenberg, you heard these members, they want to go home. Let's not waste their time. I'm asking you a simple question. You might have been accused 100 times. I'm just talking about one specific time in respect to your suspension. Were you or were you not accused of sharing confidential tax information?
Chairperson, I've just answered. I don't know why I was suspended.
Did I mention the word suspended? I'm saying, were you not accused of sharing taxpayer information?
I've answered you, Chair. I have been accused of it, yes.
At the time, in 2014, 2015?
In 2014, in 2015, in 2016, up until today.
Okay, let me put it to you that you are just being unnecessarily evasive because you know that you were accused around the issue of your suspension. You were accused of having shared taxpayer information. You know that. You're just evading the question. What do you say to that?
I can't answer you better than I have, Chairperson.
Okay. Who were you accused of sharing the information with?
In early 2014, I was accused of unlawfully sharing taxpayer information with a lady that I had briefly dated. This adapted towards middle and late 2014 into 2015, that I had supposedly unlawfully shared taxpayer information with various persons in the media.
Yes. Okay. So the first accusation was that you shared confidential tax information with your girlfriend.
I did so unlawfully, yes, Chairperson.
Yes, it's always unlawful to share taxpayer information.
Not necessarily, Chairperson.
Okay, but in this case, you had shared it unlawfully. So you're saying you can share confidential taxpayer information with your girlfriend lawfully?
It depends on circumstances.
Of what? Of you or the girlfriend?
It depends on the circumstances. Depends on the nature of the conversation.
Okay, now let's make it easy again. Just give me one set of circumstances where it might be lawful to share confidential taxpayer information with your girlfriend.
Where the girlfriend is providing information to me that pertains to the execution of my duties.
Okay, and then that then releases you from your legal duty to confidentiality.
No, in order to understand, you have to engage. But the point is, I didn't do so, Chairperson.
So she was lying.
Indeed.
And the girlfriend we're talking about is Miss Belinda. Is it Walter or Walters?
It's Walter without an S, Chairperson.
Without an S, yes. So you're saying she was accusing you gratuitously?
She's falsely accusing me. She was very specific. She said that I had unlawfully shared confidential taxpayer information in relation to President, the then President Jacob Zuma, the head of the Economic Freedom Fighters, Honorable Member Mr. Julius Malema, and tobacco manufacturer British American Tobacco.
Right, thanks. So she said you shared that information with her.
She said I shared confidential taxpayer unlawfully with her in respect of those three individuals.
Yes.
Well, the two individuals and the one business entity, Chairperson.
Okay. And this was at the time when you were involved with the so-called rogue unit or the unit, whichever term, correct?
Chairperson, can Mr. Mpofu just explain to me what, I don't understand the question.
No, I'm saying the time when you shared, allegedly, shared the confidential taxpayer information would have been at the time that you were involved with the so-called rogue unit.
I don't recognize the term, sorry. I managed 5 units at the time when I dated Miss Walter, Chairperson.
Yeah, but one of them was the unit that you are saying was not rogue, which other people say it was. When I say so-called rogue unit, I mean that one.
Yes, it was known as the High Risk Investigations Unit of the South African Revenue Service at the time, Chairperson.
Yes, otherwise known by other people as the so-called rogue unit.
I think it's disrespectful, Chairperson.
Yeah, but that's because you don't think it was rogue. I'm saying those who think that it was rogue, call it the rogue unit. You know that, Mr. Van Rockenberg. Let's move on. Don't you know that when people say the so-called rogue unit, they refer to the unit you headed?
Yes, but I've always been at pains, Chairperson, to ask that people be respectful. You cannot taint 26 people just like that. It's the equivalent of being racist.
Sorry?
It's the equivalent of being racist.
Do you know what racism is? What do you mean by that?
You cannot just call a group of people something with a negative tone. I don't think you even know the people, Chairperson. So I've always objected against the term. The unit was known as the High Risk Investigations Unit. Chairperson, I request that it be referred to that. It's disrespectful, that's all.
Okay, thanks. Well, you can't stop me. I'm going to refer to it as the so-called rogue unit. The word so-called means, that's how it was referred by other people. But okay, let's try, for the purpose of moving on at this stage, call it the unit. When I say the unit, you'll think whatever you think, and I'll think so-called rogue unit. So the accusation was at the time when you were heading the unit.
Yes, correct, Chairperson.
And how old are you?
I'm now 53, Chairperson.
Okay. So would it be fair to describe you as a security man, a person who's in that world of security, broadly speaking?
Chairperson, can Mr. Mpofu just explain what he wants me to answer to? I don't understand the question.
Okay. Just repeat your question, Advocate Mpofu.
Yes. No, maybe I'll try and break it down, Chair. Did you serve in the South African Defence Force?
No, Chairperson.
Did you serve in the police? Where did you get your experience as a security person?
I don't know what security person means, Chairperson.
High risk or rogue unit dealt with security matters, didn't it?
The high risk investigations unit conducted high risk investigations, as the name says, Chairperson. It did
Yes.
not deal with security. It dealt with South African Revenue Service, tax and customs legislative related offences.
And one of the things you trained them in was use of firearms, correct?
No, Chairperson, I did not train them in firearms.
All right. And you were doing surveillance with what you call the mafia.
No, Chairperson, we were not doing surveillance with the mafia.
Did you do surveillance with the abalone rings?
Yes, on odd occasions, we did lawful surveillance in order to collect evidence to prosecute tax and customs offenders.
Okay, lawful surveillance, what does that mean in normal English? It means listening to people or watching their movement or taking their photos. Just say it in normal lay. Most of us here are lay people, except General Olumis.
It's like many of the members of the committee now observing me, Chairperson, and I cannot observe them, and I don't know who they are, and I don't know how many of them are observing me.
Okay, so what we are doing here, this is surveillance.
Yes, Chairperson. It's looking with your eyes in the public domain.
Okay, so all human beings then are involved in surveillance when we look with our eyes.
Yes, Chairperson. The difference here is you do it in order to, where you have reason to suspect, say, a state warehouse that is under the control of the Revenue Service is about to be robbed, then you place people there to observe the warehouse to ensure that it's not robbed, and in the event that it's robbed, that you can act on the robbery.
All right. And you would agree that the unit that you headed, some of the work it did intersected with what we generally know as intelligence work?
All 5 of the units that I managed can be described in that manner, Chairperson.
Pardon?
All 5 of the investigative units that I managed over those years can be described in the manner in which Mr. Mpofu has just described.
So, sorry, I think maybe it's my ears. I couldn't hear the first words.
All 5.
All 5.
All 5 units that he had managed.
Okay. Oh, so it's more, you had 5 units.
It's common cause, Chairperson.
Yes. All of them were involved with intelligence work.
No, your words were different. If you could just repeat what you said in your first question, it's a different question to what you're saying now.
Yes. The first question was, would it be fair to describe the work that you did in the unit? And I thought you and I had agreed that which unit we're talking about, but you introduced 5 now. But would you agree that the work that you did in the unit involved what is generally known as intelligence work?
No, I would not agree, Chairperson. Your first question, the first question, Chairperson, posed to me by Mr. Mpofu was whether I would agree that the unit can be described as having intersected with intelligence. My response to that was that is applicable to all 5 the units that are investigative units that I managed. The question Mr. Mpofu is asking me now is a different question. He's asking me whether I can describe the work conducted by the unit in question as being intelligence. My answer is no, it was not intelligence.
Okay, would you go as far as to say it had nothing to do with intelligence, or did it have something to do with intelligence?
Yes, I've answered you in the previous question, Chairperson. I
again.
did say it intersected from time to time. Indeed, they worked together with the South African Police, the National Prosecuting Authority, the Asset Forfeiture Unit, all the law enforcement and intelligence agencies of the country.
Good. Now you know what security means. So those kinds of agencies, South African Police, National Intelligence, and the ones that you've listed, that's what I meant. Remember, what we're doing now is because you claimed not to understand what I was saying when I say you were an operative in the security cluster or in the security sphere. Do you now understand what I mean by that?
Chairperson.
No, I'm not sure, but
you don't know what security, what the security or what you call law enforcement sector is? Or are you not sure about that?
oh, law enforcement is a different, that I understand, yes. Security is one set of law enforcement.
You're fine. Okay, go ahead, Advocate Mpofu.
All right. Now, at the time of your suspension, were you aware that there was an opinion by Advocate Brassi dealing with your, among other things, your suspension, as well as the Pillay matter?
No, Chairperson.
Pardon?
No, Chairperson.
You've never seen such a thing? Or heard of it?
No, Chairperson.
Never heard of it?
I've heard in loose talk of Advocate Brassi's comments and documents, but nothing's ever been put to me.
Okay, I don't believe what you're saying, but we'll deal with it some other time.
Perhaps you can provide it to me, Mr. Mpofu.
Yeah, I will. It's in the documents here. My team will call it up. It's
I
in
would
the
appreciate that, Chairperson.
that before the committee. And you know that one of the institutions that was set up, for lack of a better word, around your conduct or alleged misconduct was the Sikhakhane investigation, correct?
Yes, Chairperson. It became known as that, yes.
Yes, yes. It became known as that. But actually, it should have been known as the investigation into the conduct of Mr. van Lochrenberg.
That's the title of the document, Chairperson.
Yes. And you, one of the things you say to this commission is that the public protector must be impeached because, among other things, she placed reliance on that report, correct?
That's an oversimplification of what I'm saying, Chairperson.
Okay.
I'm saying, I'm certainly not saying that Ms. Mkhwebane must be impeached. I'm simply participating in a committee to display that Ms. Mkhwebane ignored my basic human rights and natural justice in respect of Report 36 of 2019-20.
Yeah, no, I know that. I mean, we all heard it yesterday. She ignored you. She ignored you as if you don't exist.
Yes, Chairperson. The same applies, by the way, to Advocate Sikakane.
Yes, and you are saying, you are not saying Ms. Mkhwebane must be impeached. Is that your evidence now?
Not my evidence. I'm describing the nature of my complaint, Chairperson. It is for the committee to make determination, not for me.
Did you not say that Ms. Mkhwebane is not fit and proper?
Yes, I did say that.
So if she's not fit and proper, what must happen?
That I leave up to the committee, Chairperson.
Advocate Mpofu, would you mind taking a pause there? We'll take a 15-minute break.
Thank you, Chair.
And be back at 11:45. We'll resume at that time. Thank you.
Chair, do I remain seated or can I have a couple of
Please, Mr. Van Lochenbeck, please refresh yourself, relieve yourself, drink coffee, tea.
Thank you, Chair.
No whiskey, please.
Welcome back. We'll now resume. Mr. Johan van
Recording in
Rossum,
progress.
Are you on the platform?
Yes, Chairperson. Can you hear me, Chairperson?
Yes, yes, I can hear you. Advocate Mpofu, please proceed.
Thank you, Chairperson. Mr. van Lochenberg, is it correct that Ms. Walter is now overseas?
I don't know, Chairperson.
You don't know? Okay. Yeah, we're trying to reach her to get some more information. But one of the things that she has indicated is that you said you are taking medication for what?
I'm undergoing a series of medical procedures on my jaw for the next couple of months. Yeah, so it just causes a bit of discomfort and
pain.
Yes, and it's difficult to speak. But I'm okay. Thank you for the concern.
Thank you. Okay, I'm sorry. I was just about to say I'm sorry then, because I'm here, or we're here to make you speak. But
it's okay. I understand, sir.
Thank you so much. Okay. All right, but you have not had a mental problem.
I don't know what you mean. Can you be more specific, please?
No, I mean, have you had a psychiatric type of problem?
Yes, I was born with one.
With one, okay. All right, thanks. I think we'll leave it at that. Ms. Walter, maybe we'll deal with that issue if we manage to find her. Okay, thank you. No, I just wanted to know that you are okay for this process, apart from the pain and discomfort, for which I apologize. All right.
Chairperson, I'm happy to explain to Mr. Mpofu if he wants to know. I doubt whether Ms. Walter will know more than I do. The affliction is my affliction.
I'm sure she won't, but well, she might know it from the receiving end. Yeah, but I'm saying that the reason why I was moving on is I didn't want to breach your confidential.
Thank you. Thank you, Advocate.
Yeah, that's definitely not my intention. So I think let's rather leave it at that, Mr. van Lochenberg. All right.
I've written a book about it, Chairperson.
Okay, well,
it's okay, Mr. Johan van Lochenberg. Please proceed, Advocate Mpofu.
Thank you very much. Yeah. All right. Now, Mr. van Lochenberg, we were busy with the Kanye report. It's fair to say the Kanye report found that your so-called rogue unit, or whatever you call it, was unlawful.
Yes, it did suggest that.
No, not suggest. It found that it was unlawful.
No, I don't think it made findings. According to Advocate Kanye in later interviews, he said all he did was recommend that these matters be further investigated.
Okay, but did he say that, let's not be legalistic about it. Did he say that your unit was unlawful?
He did.
Okay. And then there was also the Kpmg report. It also found that the unit was unlawful and had some unlawful activities, correct? Yes?
Yeah, in a very general sense, it did say so in conclusion.
But it did, found it unlawful.
In the conclusion, which it withdrew, it did make such a statement in a general sense without any explanation.
Yeah, but it did not withdraw the part that your involvement in the unit, or that the unit was unlawful, did it?
We did withdraw that, Chairperson.
Okay, all right. Were you happy with that?
Well, I'm more happy now that the Revenue Service, who used Kpmg and Mr. Sikakane as service providers, have publicly rejected both reports and emphatically saying that they were procedurally and substantively not problematic and not to be relied upon for any purpose.
Mr. Van Lachenberg, we'll move faster if you don't evade my questions. Were you happy with the alleged withdrawal by Kpmg?
No, I was not.
Why were you not happy?
I wanted them to do more, Chairperson. I wanted them to explain how it came about that they said the things that they said.
Yes, but this is a point I'm making. You complained about the alleged withdrawal of Kpmg exactly because they did not withdraw everything in their report. It was a qualified withdrawal, isn't it?
It was one of the matters I raised at that point in time when only that portion was withdrawn, Chairperson.
And then that subsequently, did they withdraw the portion you wanted to be withdrawn?
The whole report is void.
No, man. I'm sorry, Mr. Van Lachenberg. I'm saying, just answer my question. You're saying at that point in time you were unhappy because they had withdrawn a particular portion. I'm saying, and as we sit now here, did they withdraw the portion that you were unhappy that they did not withdraw?
Yes, they did, and I am happy.
So there was another withdrawal. When was that?
There was one withdrawal, Chairperson. I had engaged Kpmg since 2015.
Okay, Mr. Van Lachenberg, maybe it's me. I'm saying to you, there was a withdrawal which you are unhappy about, correct?
Correct.
And that was the only withdrawal, correct?
Correct.
So therefore, the part that you were unhappy about, they've never withdrawn, correct?
No, I said they did withdraw that, Chairperson. They withdrew their findings, conclusions, and legal opinions.
All right. I'm sure maybe the, excuse me, the
That is what was withdrawn, Chairperson.
Yeah, completely.
That includes the statement about the unit, that it was unlawfully established.
All right, we'll come back to that. The other independent body that found that your unit was unlawful was the Kruan report, correct?
No, Chairperson.
They never found that it was unlawful?
No, Chairperson.
Okay. What did they find about the unit?
They made no findings, Chairperson. They issued a media statement in April 2015, and Judge Kruan explained it in quite some detail on oath before the Commission of Inquiry into Administration and Governance at the South African Revenue Service in 2018, and subsequently also in a written public apology to me and other people.
You see, Mr. Van Lachenberg, I don't know, I think there's a problem either of what I'm saying or you comprehending it. You're jumping to 2018 now. I'm saying to you, okay, let me put it this way. This, what you're saying they apologized, what were they apologizing for? What did they do wrong?
They apologized for issuing a media statement.
Saying what?
They endorsed the Sikakane report.
Thank you. So insofar as the Sikakane report had found that the unit was illegal, it was endorsed, to use your word, by the Kruan panel, correct?
In April 2015, correct, yes, sir.
No, okay, thank you.
It's not a finding, Chairperson. That's my point.
Yeah, whatever you call it, an endorsement. Let's call it that. Let's use your word. The finding of unlawfulness by Kanye was endorsed by the Kroon panel, among others. Anyway.
At the time, correct, Chairperson.
Yes, thank you. Then the fourth body that found that the unit was actually criminal, if it went even further, was the Inspector General's report, correct? Inspector of Intelligence. Inspector General of Intelligence, sorry, Chair. That was the fourth body that found that the unit was unlawful, and in fact, this time it said it was criminal, involved in criminal activities, correct?
Yes, Chairperson.
And can you tell us what was the Kanye report?
The Kanye report was a panel that was set up to investigate the allegations made by Ms. Belinda Walter against me on 28 May 2014.
About the thing we've already discussed, the excuse me, leaking by you unlawfully of confidential taxpayer information.
It started with that, Chairperson, and then she added a whole string of false claims to that.
Okay, can you tell us those claims, those that are relevant to the issue of the unit?
None.
Okay. Right. And did, insofar as the issues to do with the unit, and you've already established that the alleged leakage of information was done in the context of the unit, what did the Kanye panel find?
I'm sorry, could you repeat that, Chairperson? We've already established what?
Sorry, no, yeah, there was some interference here. Okay. What did the Kanye report establish in relation to the leaking of taxpayer information?
It's in the court papers. If you allow me, Chairperson, I can find it quickly.
Now you can paraphrase so that we move on.
Oh, they found Ms. Walter's claims to be unsubstantiated. She undertook to go on oath and she refused to do so. She undertook to provide evidence and she did not do so.
Oh, okay, so she didn't appear before the panel.
I believe she did.
Oh.
I did not appear before the panel.
You didn't. Okay, that's fine. No, that's fine. She'll speak for herself.
The panel concluded its findings without even hearing me.
Yes. And yeah, I know that you feel very strongly about this issue of, you've made this example of the public protector. Imagine the public protector being brought here and not being given an opportunity to be legally represented. Remember?
Yes, Chairperson, I wish I had Mr. Mpofu with me back then.
The feeling is mutual, Mr. Unlawfully.
These wishes and feelings.
Yes. Yeah. Now, do you think that, well, if I tell you that that's exactly what Parliament wanted for the public protector to come here without Mr. Mpofu, or do you think they must be impeached? The Speaker and this committee, members of this committee, passed rules which excluded legal representation, which the courts found to be wrong. So that's not the point I'm making. I'm just saying, do you think that the mere fact that they denied her Audi is a cause for impeachment?
I actually don't know enough, Chair, and I feel uncomfortable to give a meaningful response that would honor the question posed by Mr. Mpofu. I think the fact that Ms. Mqwebane is being represented in this process, and the fact that she's being afforded the opportunity to hear all of us and cross-examine all of us on oath and in public, openly, is a very good thing. It's how it ought to be. This was certainly not the case in the Kanye panel, nor the Sikakane panel, nor the Kpmg process, nor the Kruan media statement, nor the Inspector General of Intelligence process, and the Public Protector process. At no stage was I afforded what Ms. Mqwebane is being afforded now.
No, we're together there, Mr. van Lochenberg. In fact, you are even in great company because the Constitutional Court agrees with you. That's why I'm here. I'm asking you a simpler question, that the mere fact that the Speaker went up to the Constitutional Court to deny that right that you and I agree should be extended, which is the right of Audi. Does that mean that the Speaker must be impeached? Again,
Chairperson, I don't think I'm qualified. It's not why I blew the whistle to this committee. It's certainly not why I'm sitting here today. It's to debate complex legal issues that I don't feel comfortable in expressing a meaningful view. I can give you what my instincts suggest, but I don't know enough.
Okay, no.
I'm sorry, Mr. Mpofu.
No, I forgive you. So it was your example that I'm using, actually. That's why I didn't want to come with complex legal issues. I'm just following your example because you said this twice. You said it yesterday and today, that let's imagine what if the public protector was denied the right to a hearing or the right to legal representation. So I'm using your own example, but fine, if you are now finding it complex, let's...
Well, for me, the fact is that justice has been served. Ms. Mqwebane is sitting next to Mr. Mpofu, and she's participating in the process fully, and it is in the open public domain.
Yes, I agree. No, that I've already said we agree there. That's why we brought it to the highest court in the land. But anyway, the point I'm saying is that the gist of your complaint is that you were not afforded a hearing. Am I right? Or you were ignored, to use your words?
If you want to simplify it to that level, yes, Chairperson.
Thank you. And then I'm saying, okay, if you simplify it to that level, because you were ignored and not given a hearing, then Ms. Mqwebane is not fit and proper in your estimation, correct?
Yes, Chairperson, because she acted contra her own laws.
Yes. No,
I'm an implicated person. I was supposed to be not only heard, but be provided with what she was going to make her findings on, and be afforded an opportunity to participate. And even if I wanted to cross-examine people in terms of the specific process within the Act, if I so elected, none of that occurred. My complaint adds another aspect to it, and that is that Ms. Mqwebane in her public statements referred to this unit emphatically as a rogue unit, not as you do, Mr. Mpofu, as a so-called rogue unit. She then stated in no uncertain terms that people have died because of this unit, and that people's names have been tarnished and that this will still continue going forward prior to her having concluded her investigation. She then made certain statements which we heard yesterday to the Inspector General of Intelligence. That is the essence of my complaint, Chairperson.
Yes. No, I understand. I understand, Mr. van Lochenberg.
Thank you.
Before we come to what you've just said now, I just want us to conclude what I was trying to say to you. And if you can't answer it, I'll move on. I'm simply saying, maybe I'm doing it in an indirect way. Let me do it more directly. You would agree that the mere fact that an institution, whether it's Parliament, whether it's the public protector or whatever, has wrongly and unlawfully denied somebody a hearing, an opportunity for a hearing, does not necessarily mean that they are not fit and proper for their office, as a general statement.
As a general statement.
Thank you. That's all I need from you. Yeah. Okay. Then let's then come back to the statement that you just made now. You're saying if she had called it a so-called rogue unit like you and me now, I mean, if we had qualified it or say that's what people say, you would have been happy.
No, I would not have been happy.
But you'd have been happy, yeah.
No, I would not have been happier, Chairperson.
So why did you then refer to the fact that she did not refer it like you, Mr. Mpofu, as a so-called rogue unit? What was the value of that? If it
because there's a difference, Chairperson. She did so in her capacity as the public protector, who at that point was besieged with investigating allegations about that specific unit. She then calls that specific unit a rogue unit. That suggests to me that she considers the unit to be a rogue unit, not a so-called rogue unit. The difference in meaning, Chairperson, it's about semantics. And I understand semantics is very important in this entire saga. It's like the claim that the existence of the unit has always been denied. Well, evidence shows it's never been denied. What has been denied is that the existence of a rogue unit has been denied. There's a difference between the two.
Yes. Well, I put it to you that what you're saying is bizarre, because that is exactly what Ms. Mkhwebane or Advocate Mkhwebane was accused of saying, that it was a so-called rogue unit, like I did. And you've been misleading this committee for 2 days now to say that she did not do that as I did it, correct?
No, it's incorrect, Chairperson. If I can direct you to my affidavit to this committee, I don't know what the reference number is
to this.
Your...
Okay, I'm also working from hard copies. It's 527. I don't know the bundle A.
In the bundle that I have, Chairperson, it is numbered 2, and it's got a number 1 on the left and a number 70 on the right.
Yeah, that's 2.1.70. Yeah.
Yeah.
Okay. Does it have a typed page 527?
Sorry, Mr. Mpofu. You've got the record of the affidavit that was filed in the public submissions.
Yes.
We then culled it and put it into the witness bundle.
Oh, yeah. But it's
so
the same
it starts
document.
on page 70 of the witness bundle.
Okay.
So maybe it would be easy if you just use paragraph numbers.
Can put it up. Okay. Oh, yes, you're right, Ms. Power. Yeah. No, it's not me who wants to use it, it's the witness. Then use the paragraph numbers, if you may, of the place that you want to refer us to, of your affidavit.
Yes, Chairperson, it's paragraph 6.
6. Yes.
And it's
Yes.
the very last sentence, Chairperson.
It says for ease of reference.
Correct. It reads, for ease of reference and record purposes,
Yeah.
I attach here to as JVL1 a letter addressed by my attorneys in this respect.
Yes.
If one scrolls down to JVL1,
JVL1 would be the letter from Weber Wenzel. Correct?
Worksman's, isn't it?
No, it's Weber Wenzel.
that's correct, yes, Chairperson.
Okay, so
Sorry, JVL3, it's my mistake, I apologize.
that's correct. Okay, can you go to paragraph 3 of that letter?
No, it should be paragraph 1.1.
Yes, no, can you go to paragraph 3? You can go to paragraph 1.1 if you want later.
The page number is 84 or 15.
Are you at paragraph 3? What's it?
I would like to just take the committee's
Oh, thank you. Yes, no,
attention to paragraph 1.1. It's that page, Chairperson, or yes, Chairperson. Paragraph 1.1.
No, I'm saying, can you go to paragraph 3?
Well, I'm answering Mr. Mpofu, Chairperson, so I want to just finish my answer.
Okay, let's start at 1.1 and then we'll go to paragraph 3 so that you complete your answer.
Correct.
Okay, there's
at paragraph 1.1, there's the last sentence reads, your video can be accessed from the following link. And then there's a link to a YouTube video.
Are you done? Can you go to paragraph 3 now?
No, I just want to answer the question, Chairperson.
Okay, answer the question.
I'm the one who's asking the questions here. I don't know what question I'm telling you.
I'm answering the question.
Okay, let's allow him to conclude, Ms.
All right. Okay, do whatever you want
Please,
to do.
Answer the question, Mr. Van Lochenberg.
Sorry, Chair.
Chairperson, if one listens to that YouTube press statement, which was published by Ms. Mqwebane in her capacity as the public protector, it was in June of 2019. She makes reference to the unit as the rogue unit on 3 occasions in that link.
Are you done?
Yes, Chairperson.
Can you go to paragraph 3?
Okay, just go to paragraph 3. Just a pause, Honorable Gondwe.
Chair, thank you. Through you, can I please ask that we have a listen to the video if possible, just for record purposes?
The video?
Yes.
It's the one we listened to yesterday?
No, there's a link there.
Now?
Yeah. You want to listen to the video? The one that is being referred to by Mr.
Mr. Chair, can I maybe make a practical suggestion that Advocate Mpofu continues? We try and source it during the lunch adjournment so that we don't interrupt and then do that.
Are we on paragraph 3? Advocate Mpofu?
Yeah, well, I don't know. I've been trying for...
Just repeat what you want him to respond to in paragraph 3.
Yes, can you read it out, paragraph 3?
Okay, Chairperson. In addition, your Facebook posts and tweets include the following false allegations regarding our clients: threats of arrest for money laundering, etc., and poisoning since I started investigating the so-called rogue unit.
Yes. So she referred to it as the so-called rogue unit, which you just said you prefer that reference, but you did not tell the committee about that. Am I right?
I do not prefer that reference, Chairperson, and I've never said I prefer that. This is an instance where she does refer to it as the so-called rogue unit. If you go to the paragraph just before, which is paragraph 2.
Yes. No.
I read from what is said in the video, which I've drawn the committee's attention to. Your video at approximately 4:17 contains the following false allegations regarding our clients. When it comes to issues of the rogue unit, people have lost lives, people have been tainted, and I think that is still going to happen.
Yes, Mr. van Lochenberg, and you must listen to me very carefully.
Yes,
I didn't say that she did not on other occasions refer it like that. I'm saying this committee must be given balanced information. Would you agree?
Yes, Chairperson.
Nothing should be concealed from it. Would you agree?
Yes, Chairperson.
Whether that is adverse to Advocate Mkhwebane or favorable to her, the committee must be placed in a position to weigh all those things. Would you agree?
Yes, Chairperson.
So if she referred to the unit as a so-called rogue unit, that would mean that at least at some point she acknowledged that that is how it is referred to by others. She was indicating that, which is what I was doing too, correct?
Yes, Chairperson.
Thank you. Now, I was saying then the public protector, because remember, ultimately, that's what this is about. The public protector, in your view, is not fit and proper, among other things, because she correctly or incorrectly relied on these reports which said that the unit was unlawful and had exceeded the bounds of what is allowable in law and even in the Constitution. And here I'm not debating for now whether indeed that is so. I'm just saying that the fact that she relied on reports done by senior counsel, by a judge, an audit firm, and the Inspector General of Intelligence, unrelated bodies who all found that the unit was unlawful. You accept that she relied on those?
I accept that she relied on those documents, yes, Chairperson.
Yes, thank you. In other words, it's not like she just woke up one day and decided, oh, let's go and harass Mr. van Lochenberg. There were independent, but when I say independent, I know you are saying, for example, they didn't give you a chance and so on. I'm not debating that, but I'm simply saying independent of the Public Protector's Office. There were independent, or let's say external bodies that had found that the unit was unlawful, including one that was specifically dedicated to you as the investigation on Mr. van Lochenberg's conduct, correct?
I just want to make 2 points in respect of that, Chairperson, in response. One is that as much as the panels, or whatever we want to call them, were seemingly independent in the sense that those people that chaired those processes were independent of each other. The input, in other words, the unknown people who made these allegations behind closed doors, never to be seen or be put on oath, were the same. So in that sense, it was not independent. Secondly, in the case of the Kroon media statement, there was in fact no process. It was merely an endorsement of a prior report. That's my answer, Chairperson. The public protector then did not wake up one morning, as Mr. Mpofu says, and decided to harass me. The public protector took those reports as is and ignored the aspects that I've mentioned and many other aspects that have been available in the public domain that cast significant doubt on those reports. And she then accepted them as if fact.
All right. Sorry.
Just a pause, Advocate Mpofu.
Thank you, Chairperson. Chairperson, I'm just trying to, and I apologize for interrupting your cross-examination, Advocate Mpofu.
No
I'm just trying to understand the timeline of these various reports and the Public Protector's Report 36, which was, we know the Public Protector's report was in 2019. But when were these other reports made, and when exactly were they overturned or withdrawn by SARS?
Okay, thank you.
Maybe if Mr. Van Lochenberg can answer that. As far as I know, the Skakane report was never withdrawn by anybody or reviewed, but I stand accused. I mean, I stand to be corrected. Looks like Mr. Van Lochenberg has got other views. Mr. Van Lochenberg, did you hear that question?
Yes, Chairperson. The panel that became known as the Kanye panel existed between June to August 2014. At that stage, there were no allegations or claims of any unit at the Revenue Service. They were purely claims made against my person. The person who made the claims ultimately did not go on oath as undertaken and did not provide the evidence as sought by that panel. The second panel came about shortly thereafter, around September 2014, which was chaired by Mr. Musi Sikakane, and that's why it became known as the Sikakane panel. And its report, I would come to discover later, was finalized in October of 2014. That panel was also not set up to investigate any claims of the unit at all. In fact, there were no such claims. Paragraph 57 of Mr. Sikakane's final report to the South African Revenue Service said that, I'm paraphrasing, during the course of the inquiry, newspaper articles began to talk about a covert unit, and it would be remiss of this panel to not look into those investigations. And then it elected to do so. And paragraph 57 then continues by saying, but by this time we had already interviewed Van Lochenberg. And it says somewhere else explicitly that it was not mandated to look into the unit. They took it upon themselves. The Inspector General of Intelligence process ran parallel to the Sikakane process. It commenced in August following media articles about various operatives and units in the State Security Agency, and it seems to have also, which we discovered years later, was concluded at the end of October. So it more or less ran parallel to Mr. Sikakane's process. The Kruan board was announced to be appointed in February of 2015. It first sat in late March 2015, and it issued a media statement in middle April. In other words, they just existed for about a month or so by way of a press conference. And then they attached the Sikakane panel report, or they allowed the Revenue Service to do so, to their media statement. And that was then the first time I came to read the Sikakane panel report. The Kpmg process commenced in December 2014 and concluded somewhere around September, October 2015. That report was never officially released by the South African Revenue Service. It was leaked to the media, just as Mr. Sikakane's report was also leaked to the media, just as the Kanye report was leaked to the media. If I can call it, the controversies around the respective reports in terms of a sequence or a timeline is as follows. In December 2014, the then Deputy Commissioner of the Revenue Service, Mr. Ivan Pillay, obtained legal advice and addressed the then Commissioner of the South African Revenue Service, Mr. Tom Moyane, highlighting the procedural and the substantive deficiencies of the report. And he warned that the release of this report could have serious consequences. So that was the first thing that happened. In January, February, March, April, and May, those 5 months, several of us sought advice to approach a court to somehow seek to review and set aside Mr. Sikakane's report. But we were advised by eminent advocates that it is not the kind of report that can be set aside because it's not an administrative action. It's akin to a legal opinion, and only once the Revenue Service takes action on the opinion can that action be considered potentially an administrative action which can be reviewed and set aside. So we were hamstrung in that sense. I engaged Judge Kruan from early 2015, and this culminated in a complaint to the Judicial Service Commission, which was resolved amicably in March 2019, where he provided me with a written apology, and he also addressed one to a number of people at the South African Revenue Service through the Judicial Service Commission. In the year prior, in 2018, around September, Judge Kruan also appeared as a witness before the Commission of Inquiry at the South African Revenue Service, in which he recanted his media statement and said indeed they had made a mistake, and he explained how the mistake came about. Kpmg began to backtrack on their report as early as December 2015 at the press ombud complaint, when the press ombud inquired about the status of and the validity and the accuracy of their report by explaining to the press ombud at the time something around the fact that the report was an internal report, not intended for public consumption. Shortly thereafter, in 2016, Kpmg issued a statement to say that their report was not the result of a forensic investigation, but rather of a documentary review, which had limitations. And one of those limitations was that they were not allowed to engage with those people implicated in the report. And then towards middle 2017, Kpmg withdrew the recommendations, findings, and legal opinions and repaid the South African Revenue Service the full fee of 23 million rand that they had been paid for the report. Their head of forensics at the time also appeared before Parliament around that same time in 2017 and in 2018, in which he also made a number of admissions. He also appeared before a panel in 2017 and 18, chaired by Mr. Dumisa Sebeza SC, which was instituted by the South African Institute of Chartered Accountants, in which he effectively stated something to the effect that some of the findings and recommendations were imposed upon them by external parties who were not part of the process, and that it was a copy and paste job, and I'm paraphrasing. So that's roughly the sequence of events. Towards the end of 2019, middle 19, is then when the public protector report comes out. I think if I'm not mistaken, it's in July. It's the 5th of July. And then the first time that I get to know what's contained in, first time I get to know that there is such a thing as the Inspector General of Intelligence report of 2014, and that I get some insight in it, is during the interlocutory process in, I think, August, September, October of 2019. So that's post the publication of the Public Protector's report. That's how I would broadly sum it up. Thank you, Chairperson.
Right. Thank you. Okay, we will supply all those reports to the commission. Those that are not already before you, to the when we lead our own evidence. Mr. van Lochenbeck, I think you were asked to give the timeline, but you gave more than that. So let's get into some of the issues that you have raised now. The issue of, let's start with Judge Kroon. Do you know that Judge Kroon was sitting with, I think, 6 other people in his panel?
Yes, Chairperson.
And when he issued that apology, was he issuing it for himself or for the other people?
He was only able to do so himself, but he did say in explanation, both in 2018 before the Commission of Inquiry of the South African Revenue Service, and also to me through the Judicial Service Commission, that around the time when they had issued the statement, the committee had come together because there were multiple media inquiries precisely on that particular issue. And he then said, in no uncertain terms, in fact, to me, he said so on oath, that the entire panel had then agreed that they ought not to have issued that portion of the statement. That's shortly after April 2015.
So you're
It
suggesting,
just never became public.
yes, so you're suggesting that he was apologizing for everyone.
It would be the equivalent if Mr. Sikakane or, Mr. Sikakane apologized to me.
I see. So if if 6 out of 7 people apologize, is that the same as if 1 out of 6 apologized in your estimation?
Chairperson, it's known as the Kroon Committee. He was the lead. He was the judge.
All right. And all right, no, we'll bring all that evidence at a later stage. And the
But Chair, I think if I may just emphasize the point, what Judge Kroon said in no uncertain terms on oath was that the entire panel agreed that they ought not to have issued that statement that concluded that the unit had been unlawfully established.
And he said, he also mentioned that they had relied on the Sikakane report, correct?
Relied on Sikakane report and Mr. Moyane and Mr. Makwakwa.
Yes, now we'll come to Mr. Moyane and Mr. Makwakwa. And the Sikakane report, you're saying it was discredited by who?
Well, I gave a line-by-line response, which was published at the time, and Mr. Pilay's response was far more sophisticated because senior counsel participated in that process. It was also published in 2014.
Okay, no, sorry, I'm sure you didn't hear my question properly. I was saying the Sikakane report was discredited by whom?
By me and by Mr. Pillay.
Okay. So then it must not be believed because you don't believe it, that you acted unlawfully.
Chairperson, I made use of a post facto audi altrum partem to reply.
And what was the outcome of that? Did Mr. Advocate Sikakane apologize for the panel as well?
No, he's never responded to it. I've only seen on 2 instances. In one, he gave an interview to a newspaper where he effectively said, look, again, I'm paraphrasing. He said, look, all I did was I collected allegations of what people were saying, and I put that together for my, and this is his wording, he says, for my brew, with reference to Mr. Pillay, to be aware of these things and to look into them. I've also seen another interview on YouTube where he basically said, look, he judged no one. He judged no one in that report, including me.
Yeah, no, indeed. But he found that the unit was unlawful. That's maybe the unit is not a person, but that will take us to another debate here.
The point, Chairperson, is he may well have found so, and he did. I've already confirmed that his report does make that statement, that
yes,
the unit was unlawfully established. It is true.
Yes, and that's the
but
point.
I'm saying that, for instance, Mr. Moyane, whilst he was occupying the position of revenue service, called for another legal opinion from another sort, a colleague of Mr. Sikakane, who gave him a completely opposite view, also in writing. That, of course, didn't leak to the media, but it came out in time. But Mr. Moyane had that. So yeah, he had two silks giving him two views, saying yes, no.
I'm sure you know that is totally misleading. It doesn't work like that. Advocate Kakane was not giving an opinion. It was an investigation. But I don't want to quibble about that. And his was a panel, not council giving an opinion. But let's not get technical. You accept, at least therefore, that that report has never been retracted and or reviewed.
The South African Revenue Service, which is the client, which convened the panel and which appointed Mr. Sikakane and the other people, has formally notified Mr. Sikakane and the public that they place absolutely no reliance on the report.
Yes, and when was that?
I wonder if I'm allowed, Chairperson. I can quickly Google.
Oh, you can't remember it.
Okay, let's just say.
I think it would have been in 28.
You can Google later, just to complete the information. If you
won't hold me to it, and I will confirm it was in 2018, Chairperson.
Yes, that's what I wanted. Okay, fine. You've answered my question. I was going to say you can give a broad answer for now, and then you'll give the answer later.
Just pause, Advocate Mbofu. Honorable Kwande.
Yeah, Leboga Chairperson. Chairperson, because we were talking about when the various panels sat and gave reports, I would like to get an idea of who commissioned the Sikakane report, who commissioned the Kanye report, who commissioned the Kruan report, Kpmg, of course, excluding the one for the IGI, please.
Can a sheet be prepared for that to just list the issues and not necessarily you responding to it now?
No, I won't deal with it at all. Yeah.
Thank you. Go, please proceed.
Okay. All right. Mr. Van Lochenberg, the council that you are referring to, or the opinion that you're referring to, is that of Advocate Trengove. Is that correct?
It's one of them, Chairperson. There were many.
Oh, you just referred to one. Yeah. No, that's fine. Which one were you referring to now when you were talking?
Yeah, the Trengove opinion.
But you've never heard of the Brasi opinion?
No, I've never heard of it.
Until today?
Until today, Chairperson.
Have you read the reports that we're talking about? The reports, sorry, I'm sorry, Chair, I was unclear. The so-called rogue unit report and the Pillay report, which is the retirement report, you've read them?
Can you just direct me which, I'm not certain what Mr. Mpofu is referring to, Chairperson, if you can just direct me.
Okay, my learned friend Ms. Bauer took you through two judgments. The one relates to the so-called rogue unit report, or the investigating unit report. The other one refers to what we call in my team the Pillay report, and that's the one that relates to the early retirement of Mr. Pillay.
Just pause, Advocate
On a
Mpofu.
point of correction, I said that I went through the interim interdict yesterday, going up to the Concourse, and I touched on the Sars unit judgment. The retirement or the pension thing is a Mr. Pillay related thing. I didn't go to that judgment at all yesterday.
Okay, let's then, the other report was other judgment was the Potterell judgment, which is the earlier judgment. Okay, did you read the references to the opinions that are found in the report, or rather, let me ask you the question anyway. Did you read the retirement Pillay report?
No, Chairperson, not really, not meaningfully.
Okay. And did you put a supporting affidavit for Mr. Pillay?
And I did. I provided two supporting affidavits in 48521 of 2019, which is the Sars unit matter.
Yes.
In September 2019.
All right. Okay. Now let's go back to the last of those reports is then the IGI. Oh no, before that, you were arrested and charged, correct?
No, I was not arrested. I was summoned.
Okay, but you were charged, criminally charged.
Correct.
And why were, or rather, who were you charged with?
I was charged with Mr. Ivan Pillay and with Mr. Andries Janse van Rensburg.
Right. Was Mr. Andries Janse van Rensburg one of the members of the unit?
He was the manager of the unit for the period preceding the time that I took over the unit.
And are you aware of the statements or admissions? Again, I don't want to be too technical, by members of the so-called rogue unit about their activities that were made to enter earlier Mr. Moyane?
Can you be more specific, please, Chairperson?
You are aware that Mr. Lombard, Janse van Rensburg, and a third person, I'll give you the name now, had admitted to having participated in certain illegal activities.
No, that's not my understanding, Chairperson. I'm aware that there are partial recordings of conversations between Mr. Moyane and Mr. Makwakwa and Mr. Deval and Mr. Lombard.
Deval, yes.
Yeah, and then I'm aware of another recording between unknown persons and Mr. Janse van Rensburg, people I think associated with the Kpmg process. But again, they were incomplete recordings and out of context. Yeah, I'm aware of those, if that's what you're referring to.
Yes, no, fine, yes, okay. But insofar as they might be incomplete in the sense that maybe you don't know where the conversation ended, but you're aware that they contained, I'm trying to avoid the word confession because it's a technical term. They contained admissions of illegal activities.
I did not, I listened carefully to all of those pieces as well as the others. That was not my conclusion, Chairperson.
All right, we will also lead that evidence when the time comes. Let me I'm just going to take one example. Were you aware that there were admissions around bugging NPA offices?
Can you be more specific, please, Chairperson?
Specific about what? National Prosecuting Authority.
Yeah, I mean, are you talking about something other than what we're talking about now? Those recordings.
No, I'm talking about the same thing. I'm talking about the activities of the rogue unit, the so-called rogue unit. I'm saying that are you aware that among those admitted activities included the bugging of DSO and stroke NPA offices?
I'm aware that those were the claims, Chairperson. Yes, I'm aware of the claims, the allegations. The facts are, however, very different. Chairperson, if I may address you, please.
Proceed.
Chairperson, what I'm being asked about on matters that concern, according to Mr. Mpofu, the unit that was investigated in and ultimately findings and remedial actions made in respect of report 36 of 2019-20. That matter was taken on review. Ms. Kpmg put up her evidence, and those people that took the matter on review put up their evidence. And in the course of that, I was asked to submit what I could and be permitted in law to do. Because I have an oath of secrecy and I have limitations on me as even as a former employee of the Revenue Service in law. And I then submitted everything that I could possibly say about that unit. And I did so on oath. And it is now common cause between Ms. Kpmg and myself. So I'm just going to, if I may, refer to the document marked 2.4, which is my affidavit in High Court case 48521 of 19, which is a supplementary founding affidavit by Mr. Ivan Pillay, and attached to that then is an affidavit by myself. This is one of the affidavits mentioned in paragraph 162 of the actual judgment on this case by the court. When you go to paragraphs 7 to 16 and 38 to 50, I've said all that I could say in law about the unit, but I would like to just highlight the following. In response to the question by Mr. Mpofu, at paragraph 40,
yes, I'm there.
I wish to confirm that the unit, in all its iterations, never used or acquired any sophisticated, quote, spying equipment, nor did it unlawfully or illegally spy on any taxpayer, customs trader, or Sars subject under investigation, nor did the unit participate in the interception of anyone's communications between March 2007 to October 2014, which is the period of the unit's existence. At paragraph 42, in this regard, I wish to further confirm that the unit in any of its iterations never conducted any investigations or lifestyle audits or tracking or spying as publicly alleged. At paragraph 43, I wish to confirm that the members of the unit in all its iterations were never trained by Sars in mail theft, dumpster diving, cryptography, interceptions of communication, and the like, nor did they use such methods in any of their investigations. At paragraph 45. I wish to confirm that according to my records and my ability to reflect such, the unit conducted 81 investigations during its lifetime, all of which as a prerequisite related to tax and or customs and or excise related organized crime and serious offences. In none of these investigations did the unit rely on unlawful spying of taxpayers or traders, illegal interceptions of communications of taxpayers and traders, sophisticated, quote, spy equipment. So, Chairperson, my guidance that I seek of you is that these matters have been settled before our courts. I've responded to what in fact, what Mr. Mpofu is asking me now are things that I submit to the committee. The public protector ought to have asked of me then. The opportunity came and went. And that is precisely at the heart of my complaint. Now in June 2022, I must sit before Parliament and respond to things that Ms. Mqwebane could have asked me before July 2019. I've listened to the recordings. I know nothing about those things, and I don't know how they can be attributed to the unit, any of the 26 people in that unit. It's like saying when Mr. Picha went and shot Rhino that the unit is a poaching unit. You can't do that.
Okay, are you done?
Yes, Chairperson. If you could just help me. It's almost as if we are going back in time and relitigating things.
Thank you, Mr. Johan van Lochrenberg. Just a pause, Advocate Mpofu. Sure. No, the first guidance I am going to give is to allow you and all of us to take a lunch break. That would be the proper first guidance, so that we think through things, and we'll come back and give further guidance. Advocate Mpofu, if you pause.
Thank you, Chair. But I just want to maybe, if you allow me, just to so that I can understand the speech. Mr. van Lochenberg, just before we go to lunch, I want to understand what you're saying. So you're saying that Advocate Mqwebane should have asked you these things before June 2019, correct?
Before she concluded her investigation. That is why I'm sitting before you today, Chairperson.
Yes, but do you understand why I'm sitting before you? So yes. You're saying she must not ask questions now because now it's July 2022. So what must we do if she did not ask you those questions in 2019?
No, she's welcome to ask those through you, Chairperson. But the point I'm asking guidance on, Chairperson, is this. The courts have ruled on these matters.
Okay, we'll deal with it when we come back.
I did hear your request. I'm going to ask you, we're taking a break now, lunch break until 2. Please do what you need to do as part of your lunch break, except the whiskey. We'll resume at 2. Thank you, honorable members.
Recording stopped.
No, the access. I'll use it. And can you see the battery? Okay.
Yeah, I don't even know which one. That's all. I told you I would like to say. If you want to engage, you can. There won't be a condition available that I keep. But I think they want to get oh, yes. What files is oh. When you find the document that they want to download, you have a way which one of the file. Yeah, she didn't folder, but this file was there.